Thank you. Thank you very much. Now, before I hear submissions, and we shall begin with submissions on behalf of the claimant, I do want to make plain what I should have made plain perhaps when we began proceedings. The official and governing text of this order is the original Arabic version. In the time available, an English translation has been produced, but the governing text is the text in Arabic. And for the sake of making progress this morning, I have been proceeding on the basis of the English translation, but I want to make it clear to everyone that the official version is the Arabic version. And if there's anything arising from that, then that should be made clear to me. Well, thank you, Mr. Brannigan. Let me have your submissions.
Lord, can I suggest that, given the applicant's application, it really should for them to indicate their position first. I will.
No, I'd like to hear from you first, please.
Okay. Let me tell you where our landing point is, and then explain how we got there. We're gravely disappointed by this order that's been given. We feel it's been obtained by means of a series of misrepresentations by the other side, which we have been given no opportunity to correct. And that caused us a grave concern, as to a number of other points which I'm going to discuss with you in a second. But where we end up, my Lord, is to say that we're content, given what the order says, for you to proceed in the way that you've indicated, save for the undertaking and damages, which we say is not fair or appropriate in this situation, and doesn't work as any sort of methodology of preserving the status quo, which is what I take from your Lordship's initial observations is the intent here. So that's the landing point, and if I explain how we get there. There are a number of very concerning features of how we all come into this case. Number one is the fact that Daman has simply ignored the clear terms of your Lordship's order made in a little bit earlier this year. It has ignored it in multiple respects. Instead of ceasing trading, it has instead, since receiving the order, commenced proceedings in the Court of Cassation. Now, such proceedings were something that was expressly discussed before your Lordship on the last occasion, where I made the point that if the other side lost their appeal, they would still have the right to go to the Court of Cassation, but it would be for the liquidator who would step in to take a view as to whether or not the company's assets should be further dissipated in that way. And in your Lordship's judgment, that came with your Lordship's order, your Lordship reflected that discussion about the Court of Cassation at paragraph 33 of the judgment. So paragraph 33 of the judgment, you say to the end, in my view, the effect of the decision of the Dubai Court of Appeal taken together with the decision of the Dubai Court of First Instance is that the jurisdiction point can no longer be regarded as having realistic prospect of success, even if which is far from clear to the court, is open to the defendant to seek to appeal to the Court of Cassation. So in making the order that you did, in terms that the other side ceased trading, you did so against a background of a judgment which reflected knowledge of the fact that otherwise they might go to the Court of Cassation.
Well, I think that depends on what is meant by cease trading. Your submission is predicated on the proposition that to exercise a right of appeal in the proceedings amounts to trading.
Yes.
And I think there may be some debate about that. We won't take up time over that now. I've got your point.
The second point I would make is that, in addition to that, the other side in the Dubai courts have been using their application to the Court of Cassation to seek to block enforcement through any of our other enforcement methods, saying that those that any further enforcement of the order should be prevented pending the Court of Cassation's judgment. So in that too, they have ignored certainly what we understood to be the effect of your order, which is that trading should cease. The third point, which is a point of some concern, is that the particular decree of 2016, which is now relied upon, is a decree that was published and available before your Lordship reached his judgment.
That's right, is it? It was, as I understand it, publication of decrees is achieved through publication in the Gazette, in the Government Gazette. And I don't believe that it had been published in that fashion before the hearing. I mean, on what basis do you say that it had been issued and published before the...
We had understood that it had been certainly signed and made available on the 9th of June.
Well, that may not be enough for the decree to have become effective in law. I don't know, but I have an inkling that decrees have to be published before they are effective in law, and that publication traditionally is in the Gazette.
Well, my Lord, if that point isn't a good one, then so be it. But fourthly, a point of concern is this. Once the committee that's now issued the order has been told, we can see, if we look back at the letter that was sent to the other side. It takes a little bit of tracing back.
Yes, what page are we in?
With tab 5, bundled for you.
Yes.
Page 15.
Yes.
And we can see the letter that went, and we can see at page 18, page 17, that what the committee has been told is that there is there's an application to declare the arbitration a nullity before the Dubai courts in relation to all of the matters you can see following the little hands. The first one being the lack of jurisdiction of DAC to consider the dispute, the next one being issuance of the award by incompetent arbitration tribunal, and then so on and so forth. So what has been represented to the committee who's been asked to deal with this is the fact that all of those grounds are being pursued before the Dubai court. What the committee has not been told is that before this court, the other side have not even sought to suggest that most of those grounds are arguable. And you can see that from the judgment of Mr. David Steele whenever this came before him on the freezing injunction. If you look, and I suspect you have read it in the past, and so I'm not going to take you through every paragraph, my Lord, but if you look in tab 8,
Yes.
look at page 84,
Yes.
paragraphs 15 through to 42, Mr. Justice David Steele goes through and conducts an analysis of all the component parts of the grounds of annulment which are being pursued in the Dubai onshore courts.
Yes.
Points out, in relation to most of them, that they have not even been suggested before him to be even arguable.
Yes.
Makes firm observations as to not only the arguability but the honesty of some of those points. and concludes that to a significant extent, virtually every single ground of annulment being pursued in front of the Dubai courts is either manifestly wrong or based on obvious, untrue representations of fact. One can go through it bit by bit to see that, but if you look just, for instance, at paragraphs 25 and 26 of the judgment, where there's talk about one of the matters which being pursued in the Dubai court, it says the complaint about a failure to complete a perquisite to the arbitration in the form of reference to the engineer again was a point that was never raised during the course of the arbitration. In fact, as Ms. Nevin explains in her affidavit, the process of obtaining the engineer's decision was in fact duly completed. There had been a request to the engineer on the 9th of May and a response on the 2nd of August. The learned judge goes through it and says the contrary suggestion, namely that there was no entitlement to arbitrate absent an attempt to reach an amicable settlement, as made in the memorandum, was simply untrue. So the learned judge goes through it bit by bit. For instance, in paragraph 35, having identified some further points, the learned judge observes, both of these points struck me as unarguable, and indeed they have not been. And so your lordship can go through it and can see that whilst this committee has been told we have all of these grounds for challenging this arbitration, in line with how they have conducted proceedings to date, they have not told the committee, well, in fact, these arguments are based, the arguments we're making are based on repeated, untrue representations of fact. They have not told the committee, in fact, so obvious are these arguments that they're going to fail that we didn't even suggest to the DIFC at the phrasing injunction that they were even arguable. And they have not told the committee, even if you put those two things aside, a learned judge in the DIFC has gone through these paragraph by paragraph, observing that they either were unarguable, have not even been argued, and in a number of cases are based on representations of fact which are obviously demonstrably untrue. So the committee has not been told any of that. Nor has the committee been told the point that we made in our skeleton. Whereas it is claimed that this court does not have jurisdiction at all to consider the issue of whether the arbitration decision is a nullity, because it is said of Article 42 of the arbitration law. The committee has not been told, but there is of course Article 44, which appears to say something, that appears to give this court the express jurisdiction to consider and deal with precisely those issues. Nor has the committee been told that in fact this court, and in particular with respect, my lord, you, have expressly considered the issue of whether there's any force to the suggestion that this arbitration is a nullity under Dubai law, and have expressed in terms now, in your last judgment, the point that it is not even arguable that the decision is a nullity. The committee has been given a completely false bill of goods, and not false because there are arguments one way or another. False because the other side had chosen to not tell the committee any of the facts which I've just indicated to you, which are simple recordable facts. And so the committee has been told that this court has not got jurisdiction and has not considered the issue of nullity, against a background of this court not only having jurisdiction to do so, but having considered it and having expressed a view in your judgment as to the ground relied on for nullity. And in relation to the other grounds that had been floated before the Dubai court, previously in Mr. Justice Steele's decision, expressing in trenchant, emphatic terms not only the arguability of those points, but whether they are put forward on the basis of a true representation of facts.
Well, have I got this right? That throughout the DIFC court has accepted that it would appear that the Dubai onshore courts have jurisdiction as the courts of the seat of the arbitration to consider the nullity application.
Well, 90% that's correct.
Well, Justice Steele adjourned the enforcement application for 4 months, subject to security being provided, on the basis that by then the court of first instance would have handed down its decision on the annulment. That seems to me to show that the DIFC court is prepared to accept that the Dubai onshore courts may well have jurisdiction, and the Dubai DIFC courts are not arrogating to themselves primary jurisdiction to decide annulment. They are taking into account the intention to seek an annulment in the Dubai onshore courts when deciding what to do about enforcement.
That I agree with 100%. The 10%
And so if I may just finish.
Yes.
Whether there is a conflict as to jurisdiction between the DIFC courts and the Dubai onshore courts is something that I think is a little unclear. However, I want to make it absolutely clear that I am going to implement this order.
Of course.
The submissions you've been making to me, although they may go to an ultimate submission that there ought to be no cross-undertaking in damages,
which is what they're going to.
Don't go to whether or not I should make an order, certainly staying the winding up element of my order. And it is open to you to make your own representations to the committee along the lines that you've been addressing me.
Absolutely. So let me make clear in return, my Lord. My submissions are all going to the, which is why I set up the landing point before I had to run it. Because I recognise on behalf of my client that faced with this order, and I'm not going to seek to dissuade your Lordship, of course, from implementing the order, we have to work out what that implementation should involve. What it should involve, in my submission, if you look at the 2016 decree and you look at the order, is to try and keep in place this status quo as at the moment before the order arrived. The status quo, as before the order arrived, was that the great injunction was in place. You had made the order emerging from the hard-fought submissions between the parties on the last occasion before you, that the other side, Daman, should be wound up, subject to a 7-day stay. You had made clear to the parties that's implicit within that order, so not as something separate, but implicit within that order was that the other side should not trade. We say, okay, faced with this order from the committee, that status quo has to remain in place. The only difference in terms of my submissions to you today is to now reverse the status quo and say, well, actually, they should be allowed to trade unless you give security in the form of cross-undertaking for damages, it reverses the status quo that was in place. Because it creates a situation of, notwithstanding that, as your Lordship has observed in his second order, and as we concur and agree with, the not trading is part and parcel and implicit in your Lordship's decision that they should be wound up subject to a 7-day stay. It then reverses that in order to say, well, we're introduced this new element, which is you have to give a cross-undertaking to damages. And the problem with the cross-undertaking is that it would be a very significant thing that is going to take us a significant amount of time, particularly in the current economic uncertainties, to sit down and put together and to be able to formulate that we're going to be able to do that, or going to be willing to do that. And the reason I did the run-up as I did is to point out that it would be really quite unfair at this stage to ask us to do that as the price for preserving the status quo, whenever the effect of the 2016 ordinance, and as I understand it, the order that has been set down for your Lordship to follow, and your Lordship's thinking as to how to follow it, is simply to preserve the status quo. And that's why we say we're content, though we've got concerns about how all of this has happened, which is no reflection on this court. We are content for the status quo to be preserved, but we find it difficult and would seek to persuade your Lordship not to impose upon us the requirement to give a cross-undertaking as to damages, precisely because that does not preserve the status quo. It is introducing a new element which we can't, in the time available this morning, and probably for a number of days, be able to put in place. And our grave concern is that the run-up to this was some real concerns that the other side were seeking to conduct a number of transactions which we were worried would leave the assets depleted within the company. Your Lordship has indicated in his judgment, in the penultimate paragraph, that the sooner there's a different management, a court-appointed liquidator who's looking after the interests of the company and its creditors, the better. Your Lordship does that on the basis of what he could observe from the history of this matter. And my simple point is, now this has come down and your Lordship has to preserve the status quo, so be it. But the status quo is not one that requires an undertaking as to damages. It requires them to cease trading and for everybody to stop whilst this committee looks at and resolves this question. So it does, myself.
Thank you very much. Yes, Mr. Buderi.
Thank you, Justice Field. I will not respond to the series of assertions made by my counterpart, most of which are ill-founded and not really worthy of a reply. Taking your cue, I don't think that the court is interested at this point in a blow-by-blow account of what some people say happened and some people say didn't happen. So I will reserve comment on all those points. With respect to the proposition that Your Honor has put forth, from Daman's point of view, it's untenable to have a cessation of business, a cessation of trading. Daman is still a trading company. It's still an ongoing company with business, with salaries to pay, with other activities that it needs to undertake. It would not be tenable for the company to survive. In fact, it would destroy the company as much as and put the company under as much as a winding up order would. And we cannot accept that the purpose of the decree and the purpose of the order which was issued by the Court of Cassation had the intention of in a sense, imposing a destruction on the company. We just can't believe that that was the intention that it had. With respect to the undertaking, I would just add that even if an undertaking were given the financial and economic problems that the claimant has had, and which are notorious through the press, we would be doubtful as to its reliability in any case.
Well, look, can I just intervene there?
No, just wait a minute. Yes, go on, Mr. Baderi.
Finally, with respect to the breadth of the order which is required to be made under the decree and the breadth of the cessation of, or the suspension of proceedings, I would like to make the point that we do not consider it to be limited in the way that Your Honor has interpreted it. We believe it is all proceedings related to the issue. And Your Honor, in your order, winding up order, you described the decision of the Court of Appeal in Dubai as the game changer. And that following that decision, there was no further prospect of a annulment proceeding being successful in Dubai. That has to be called into question now, especially with the role of the committee in defining which court it is does have jurisdiction to hear that annulment proceeding. So I would see that as intimately related to the question of jurisdiction, and your decision as well as being intimately related to that question. And therefore, we would read the decree as, and the order that's now been issued as covering, including the cessation of business and all, cessation of trading and all other orders that Your Honor gave in your judgment.
Yes. Are you meaning to submit that the Moreva injunction should go as well?
Well,
the freezing order injunction?
Yes, the freezing order. We would be content with addressing the orders given by Your Honor. We do understand that going back to the freezing order is a further distance between the dispute over jurisdiction, and that Your Honor may not feel comfortable extending it to that. But we would submit that at least with respect to the orders that Your Honor has made in your judgment concerning winding up, that all of those should be covered, and as a practical matter have to be covered in order to allow the company to continue to do the minimum required to continue its corporate existence.
Yes.
Thank you, Your Honor.
Thank you very much, Mr. Baderi. Anything in reply?
It's not my practice to interrupt, and I apologise for trying to do so, but I have this concern. This is a public hearing. Mr. Baderi's attempt to suggest that Oger's finances are in some way suspect is made without any foundation whatsoever. There's been no attempt to put any evidence before you in that regard at all. It is Daman who have not paid an award which this court has found in terms. There is no proper defence to paying that award. The one point that they decided to argue before this court has now concluded is not even arguable. And it is unsatisfactory that in a public hearing, Daman would seek to try to put in the public domain a suggestion there's something going on with Oger's finances when there's no evidence for that at all. In fact, it's not even some kind of glib lawyer's words, there's no evidence for it. It's the first any suggestion has ever been made that there is anything wrong with Oger's finances. It has got a financial problem. It's that its major creditor who owes it nearly a billion dirhams has decided not to pay it. In terms of, the second point I'd make is this, in terms of if you maintain the status quo, that will put Daman under, and therefore they don't see any point in having a cross-undertaking from us. Well, the other side's shareholders could support the company if they wished. And I perenniate the fact that even Mr. Baderi says that Daman aren't particularly interested in a cross-undertaking and damages from us. His point is a rather different one, that it doesn't really matter whether it's a cross undertaking or not, and I do pray that in aid in asking your lordship to exercise its discretion and to try and work out what is the logical and correct way to preserve the status quo here, which it does appear now needs to happen given the order that's been put before your lordship.
Thank you. What I propose to do is this. First, to grant a stay of the winding up order over until the decision as to the competent court has been issued by the committee established under the decree. As to the order requiring the defendant to cease business, I will permit the defendant to put before the court by close of business Dubai time Monday a proposal as to what is required for the defendant to remain in business. That proposal must be a sensible document. It should concentrate on the minimum that is required to keep the company viable, such as the payment of salaries. And at an adjourned hearing to take place a week from today, I will consider such proposals with a view to my final decision as to the cessation of trading order. In the meantime, the defendant will have liberty to apply, so that if there is anything which it honestly cannot await a decision 7 days from now, which is vital for the continued viability of the company, then the defendant may make application on notice to the claimant, which will be dealt with in writing unless the court is driven to the conclusion that a hearing is necessary. In the meantime, the cessation of business order, of trading order, will continue over until close of business tomorrow, and will be extended beyond that if the claimants give the usual cross-undertaking in damages. When I say usual, I mean in its usual terms. In my judgment, the context of the cessation of trading order was a situation where the winding up was delayed for 7 days, if the Court of Appeal granted a further stay pending an appeal, then the order would have to be, the overall order would have to be considered. Otherwise, the cessation of trading would endure for 7 days only. That position has now changed because the winding up order is going to be stayed for up to nearly 30 days. It is for those reasons that I will require a cross-undertaking in damages if the cessation of trading order is to continue beyond a close of business tomorrow, Thursday, London time. I will issue formal orders capturing what I have just indicated, which should be available within the hour and will be issued by the DIFC registry. And in the meantime, these proceedings are adjourned over until next Wednesday, 10 a.m.
Well, Lord, in relation to the next Wednesday.
Could I just, next week, Wednesday, is going to be during the public Eid holiday in Dubai.
Oh, yes.
And the deadline for the submission of a proposal by close of business on Monday, the 4th of July. We are yet to find out what the DIFC Court's working hours are next week, but it is likely that we will be off the entire week. We should know by the end of the day today, but it is likely, as per the public sector, that we will be closed Sunday to Thursday next week. But I will know that this evening.
Sunday to Thursday.
It's likely. If not Sunday to Thursday, then we will be open Sunday, Monday, but almost definitely closed Tuesday to Thursday.
Well, traditionally, the DIFC court does not operate on a Friday. If I were to order that proposals for the minimum necessary to achieve viability of the defendant by close of business Dubai time on Friday, could arrangements be made for those proposals to be communicated to me by the DIFC court? That would be all that will be required, just for these proposals to be relayed on to me. They would be served separately on the claimants.
That's fine. I mean, in theory, I am happy throughout the week to work and provide documents as needed if Monday is agreeable to the parties, but I figured I'd flag that it is a public holiday next Wednesday. Again, if you'd like to have a hearing on Wednesday, in theory we could, as long as everybody agreed to have a hearing on Wednesday, and we could open as we are today if you needed. But I just figured I'd flag it just in case anybody in the courtroom or with you in London has any objections to sitting throughout the public holiday.
Well, thank you very much for that. For the moment, I will adjourn over till next Wednesday, and I'll kindly ask the DIFC court to consider whether that is a feasible order. And if it is, it will remain in place, and if not, we shall have to reconsider.
As far as I'm concerned, it would be fine to sit on a Wednesday. I will just make sure that there's no reason I couldn't be here, if there's nothing happening in the registry at that time. But other than that, I'm letting you know that now it would be okay.
Yes, well, thank you very much. Mr. Buderi, is it feasible for your side to, if they're going to take this opportunity, to put before the court the minimum requirements, to do that by close of business Friday?
Your Honor,
Close of business by Friday?
yes, I was going to say, I think I'd have to double check with the party, but I would think we could probably get that by close of business tomorrow.
Well, I'll say close of business Friday. If you can serve earlier, so much the better.
All right.
Because the matter will remain under constant review. And as I've said, you have liberty to apply. If there is anything so vital that it can't await next Wednesday, then you may make your application under the liberty to apply, and we'll see whether we can take it. Understood?
Yes, thank you, Your
Honor. Well, now I'll just ask whether there are any points of clarification which either side wish to raise before we close this particular hearing.
My Lord, presumably in the undertaking as to damages, it'd be an undertaking that would relate. There's two possibilities. It could be an undertaking that relates to anything in terms of their trading, or it could be an undertaking that relates to the absolutely necessary form of trading, which you have indicated Mr. Balderi should put forward a proposal for.
Well, in order to achieve a continuation of a blanket cessation of trading, I require a cross-undertaking in the traditional terms,
Yes.
exactly the same as your cross-undertaking for the Moravian injunction.
Yes.
If the court modifies the cessation order because it's persuaded that it should do so in order for the defendant to remain viable, we will reconsider the extent of any cross-undertaking, whether there should be a cross-undertaking at all, and if so, should it be in some lesser form than the traditional form.
Well, can I suggest this then, my Lord? It's a modification to what your Lordship suggested. It may be that this is what's absolutely necessary in terms of paying wages and so on, is something which my client wouldn't stand in the way of. Its real concern is the dissipation of significant assets. It might therefore be sensible for us to have seen that and so on before we start having to give cross-undertakings, which will involve significant impact of management time and no doubt speaking to banks and so on on our part. Can I suggest this, that you give us rather longer than tomorrow evening for the cross-undertaking to enable us to see what Mr. Balderi suggests by way of his, well, this is what's needed in terms of salaries and so on. We then take a view as to whether or not we wish to stand on principle and say they shouldn't even have that. And at that point, your Lordship can decide whether, if we're going to stand on that principle, there's a cross-undertaking at that stage. Because otherwise we end up in a position where management going to have to run around for the next 24 to 36 hours trying to put in place all that's needed for a cross-undertaking. But it might be 2 days later we say, well, actually, if that's what's being proposed, we can live with that.
No, I'm sorry. I'm not persuaded that I should adopt a different course. You have until close of business London time tomorrow to provide the cross-undertaking if you want this order to continue in its fullest breadth.
And if we don't, and I'm not trying to be difficult, but if the conclusion is, well, we can't, or we don't think it's appropriate to do so, what's then the effect of that? They're free to undertake any trading they want, or they're free to undertake the slim down trading?
They're already subject to the Moravian injunction, which will bite on the disposal of any material disposal of assets. I think in those circumstances, I abide by the order that I've already indicated I'm going to make. That I need a cross undertaking from your side by close of business tomorrow if the cessation of trading order is to remain in place. And the whole matter will be reconsidered depending on any modification of that order in order to allow the defendant to remain a viable company.
I understand. I just wanted
Yes.
to... Thank you very much, George.
Well, thank you all very much. That concludes today's proceedings.
Thank you.
Thank you. Thank you, Your Honor.
Unless you have any objection, I'm going to disconnect your line.
No, go ahead. Thank you.
Thank you.